Welcome back to Trial by Podcast. I'm Jemillah, and I'm joined here today with my colleague Chelsea to discuss part 2 of our series on workers' compensation reforms. If you haven't already seen it, go and watch our first episode, Overhauled, Huge Changes to Workers' Compensation Scheme. That explored an overview of the new process for claims involving relevant conduct under the Workers' Compensation Legislation Amendment, Reform and Miscellaneous Act 2026.
Yes, welcome back, Jemillah. I'm excited to get into another juicy episode on workers' compensation reforms. Now, in our last episode, we covered the new process for relevant conduct claims, which for those who joined us last time understand are claims that involve bullying, harassment, and/or excessive work demands, and also the new process the Industrial Relations Commission will play in respect of these matters. However, since we last spoke, Jemillah, there have been some further developments in respect of these type of claims.
That is correct, Chelsea. Since we recorded our last episode, the New South Wales Government commenced a public consultation on a range of proposed draft instruments supporting the upcoming reforms to the New South Wales Workers' Compensation Scheme.
Yes, but for those listening at home, that consultation period has now closed as of the 15th of May, and those submissions are under review. However, some of the documents that were released for consultation were updated CIRA guidelines covering compensation and market practice and premium guidelines, updated claim forms, commutation agreements, and most importantly, draft regulations in respect of the compensation amendments, including some interesting proposals in respect of relevant conduct claims.
Yes, particularly in respect of the administration processes for relevant conduct claims, which you will recall, Chelsea, as we were doing our research on these reforms. We were questioning ourselves, how are insurers going to handle these complex claims, especially under the strict timelines, and what evidence they need?
Yeah, and we clearly weren't the only ones pondering these questions, as these issues have been touched on in the new proposed regulations.
Yes, but it is important to highlight as a disclaimer, these are only proposed regulations and therefore are open to change following the outcome of the consultation review. Included in the proposals are regulations as to what evidence must be provided by the employee when making a relevant conduct claim, and also provisions granting insurers relief from the time restraints on determinations in circumstances where said required evidence has not been provided.
Exactly. So what's being proposed is that where an employee is making a psychological injury claim involving relevant conduct, in addition to the standard claim particulars such as details of the injury and medical evidence, the employee must now also include, as far as reasonably practical, details on the relevant conduct, including the specific nature of the event, the date, the time, the location, people involved, names of any witnesses, as well as an explanation between the relationship of the conduct and the worker's employment.
It's also been proposed that the employee must advise whether the claim has been subject to proceeding in the RIC, and if so, what are the details of the outcome of those proceedings? Because as we covered last time, where a matter involves a dispute over whether conduct is within the meaning of relevant conduct, the worker must make an application to the RIC to make a determination on this issue before the claim can progress further in the PIC or the workers' compensation process.
Yeah. And now the importance of these new evidence requirements is that if you are making a claim under this provision, the claim will only be considered to have actually been made if the employee provides to the insurer completed claim form and all the required evidence. Failure to do so would make the claim considered incomplete.
And under the proposal, if the insurer receives an incomplete claim, the insurer has 3 business days from the receipt of the claim to notify the worker that the claim is incomplete and set out the action the worker must take to complete the claim. Importantly, for the employee, until the claim is complete, the claim cannot be progressed, and the entitlements to payments do not commence until the date of completion, not from the date of injury.
Yes. Now, what I really appreciate about these new regulations is that they're clearly trying to consider the importance of ensuring procedural fairness for all parties while still balancing the importance to make sure we have efficient and effective claims processes in place. Understandably, 3 days is still quite a strict timeline for insurers to do an initial assessment of a claim, and if these regulations come into place, it's really important insurers have processes in place to make sure incomplete notifications are made on time. However, I think it will be appreciated that that the new regulations are being drafted to ensure that insurers have sufficient information at hand to be able to make their determination in respect of relevant conduct claims.
Yes, because as we discussed last time, it is a strict timeline under the new reforms to make a determination of a relevant conduct claim within 42 days, which is a rather tight timeline for assessing such complex claims. But the new proposed regulations share the burden of ensuring these type of claims run efficiently by placing the onus first on the worker to ensure that their claim is sufficiently made out from the beginning in order for the insurer to properly assess the claim, which should improve efficiency of processing claims overall.
Yeah, exactly, which is a fair trade-off. If the insurer is restricted to a 42-day deadline, which therefore restricts the opportunity to gather further evidence, I believe it's understandable that the employee should make sure that their claim is properly made out. However, that is just my opinion, of course. It will be interesting to see what the other stakeholders have to say about these proposals and the outcome of the consultation review.
Yeah, it's definitely a matter we'll keep our eye on going forward. Now, another key change introduced under the new reforms that closely ties into relevant conduct claims are the amendment to Section 11A and the reasonable management action defence.
Yes, and we briefly touched on this issue last week. For those listening at home who aren't familiar with workers' compensation, Section 11A provides that there is no compensation for a psychological injury in which the injury is caused wholly or predominantly by reasonable management actions taken by the employer.
Oh yes, but under the new amendments, that threshold has been lowered to psychological injuries which the significant cause is reasonable actions taken by the employer.
Right, which significant, predominant, tomato, what's the significance, Jemillah?
Yes, it may be small, but as we know, a simple word change can mean a lot. What this means is that unlike previously, whereas to succeed on a Section 11A defence, the employer had to prove that their actions were reasonable, and the said action was the main or predominant cause of the psychological injury. Now they only need to satisfy that it was a significant, i.e. does not need to be the main cause for the injury for compensation to be barred.
Right, so the defence threshold is being lowered. However, does this not mean that more psychological claims will be disentitled under the new reforms? Does this not seem a bit pro-employer protective?
Yes and no. Although the causative threshold has been lowered, the reforms also include clearer definitions as to what can be considered reasonable management action. And don't forget the RSC's role in determining if conduct was relevant conduct. In many cases where an employer would have previously raised a Section 11A defence, the worker's case will now be supported by a finding from the RSC that the relevant conduct was bullying, harassment and/or excessive work demands.
So true. However, I have actually been thinking, in those cases where the IRC makes a determination on relevant conduct, surely it'd be quite difficult to raise a Section 11A defence? How exactly does the Section 11A play into these matters with the new IRC findings?
That's a great question, Chelsea, and I'm sure many interested parties in the workers' compensation field are all asking the same thing. Unfortunately, I do not have the answer for today, so we will have to keep an eye out for further guidance from the legislature and see how these matters are handled once the new process comes into effect. But remember, the current reforms don't specify that the RSC has to make a finding on whether the relevant conduct did, or to what extent it did, cause the psychological injury, just that whether the conduct involved is or is not relevant conduct.
True, that's a good point. So hypothetically, in a case where a worker is bringing a psychological claim for bullying or harassment and the IRC has made a finding on that, a worker may still be able to bring a reasonable management action defence. For example, let's say a worker has made a claim for bullying and harassment and the IRC has deemed that conduct to be relevant conduct, as it is bullying and harassment. During the Personal Injury Commission proceedings, the employer may be able to demonstrate that although there was bullying and harassment, the worker's psychological condition was actually significantly caused rather by the employer's reasonable decision to put the worker under a performance review, and therefore the Section 11A defence may succeed?
Possibly. I definitely foresee this matter attracting a lot of discussion and litigation as parties work out the new shared jurisdiction between the RSC and the PIC.
Okay, I think, we definitely need to keep an eye on this and we'll keep the listeners at home updated. How about now we pivot to another area of the reforms, which we do know how they'll come into play, and that is the changes to the whole person impairment thresholds.
These changes have been a very hot topic, especially for workers who have the claim for a primary psychological injury.
Yes, currently to be eligible for a psychological claim, you need to reach the threshold of 15% whole person impairment or more.
However, this threshold is increasing and the changes are being introduced in a 3-stage process, with each year phasing in a higher percentage threshold required by the worker to be eligible for lump sum compensation.
Exactly. So rather than one big off change to the whole person impairment threshold, they're going to gradually increase the threshold over the next couple of years. For this year, any claim or notification that is received on or after the 1st of July 2026, they will need to have an assessment of a whole person impairment of 25% or more.
Following that, on 1 July 2027, this will then increase to more than 26%.
And then following that, from the 1st of July 2028, they will need to reach a threshold assessment of 28% or more.
With that being said, it will be interesting to see how these changes will affect claims and the assessment made by doctors in respect to whole person impairment, with many solicitors currently looking at the previous 2012 amendments for similarities.
Yeah, exactly, Jemillah. And this was raised during the inquiry last year into these reforms. As when we looked at the 2012 reforms, when they came into effect, increasing the threshold to 15%, the psychological claims that reached that threshold increased from 2 to 3% to 13 to 17%. Now, some stakeholders said that this change happened because there were better guidelines released, but others said it was doctors amending their assessments to reach the higher threshold. Maybe it was a combination of both.
Possibly. Given what happened following the changes in the 2012, the government has proposed an evaluation on the assessment guidelines for psychological claims. The current process to assess psychological claims follows a psychiatric impairment rating scale and is tabled to be reviewed by Parliament around the late 2027 to early 2028. It is proposed that this is also inclusive of any methods of assessing psychological impairment.
Which I think is a very strategic move by the government, allowing some time for the reforms to come into place before updating the guidelines. This will give the reforms time to be operative and the effect of them to be considered before the legislature assesses what parts of the assessment guideline, if any, need to be amended.
I agree, Chelsea. I think this is a space will continue to be evolving and mending significantly in the next few months to even the next few years. It will also be interesting to see how the Industrial Relations Commission plays a part of a Section 11A defence for relevant conduct claims and the process for whole person assessments being made for psychological claims, given the increases that are to be rolled out.
Exactly, Jemillah. And as always, we will keep you at home updated with any new commentary, regulations, or changes in the workers' compensation space. So please tune in next time for our next episode.